radio station.
Attention, attention. Are you tired of expensive, low-quality web service providers? And are you looking for stunning, amazing, high-quality websites and want your website rank on first page of Google? तो आपकी तलाश खत्म होती है यहाँ. Please contact People Inc. on 510-449-9049, 510-449-9049, or visit them at www.beerbulls.com. Beerbulls Inc. offers award-winning custom-built websites, web and mobile application development, and internet marketing services. So contact कीजिए Beerbull Inc. को 510-449-9049. आपको satisfy करना और hard work करना यही Beerbull Inc. का मकसद है.
The new Attorney On Air app is now available to download on your iPhone or Android. Get access to the latest information and interact on the immigration and debt settlement blogs. That's not all. The app has plenty of entertainment as well. Listen live to the Shah Peerally Law radio shows. Go to www.attorneyonair.com to download it for free. Yes, that's right, for free at www.attorneyonair.com. Is your credit card debt driving you insane? Don't panic and claim bankruptcy. Don't consolidate and end up worse off than before. What you need to do is call the debt settlement team at the Shah Peerally Law Group PC. They have an excellent record of getting your debt reduced at a fraction of what you owe. The best part is you don't pay a penny until a settlement is reached. Stop wasting time and money and call the Shah Peerally Law Group PC at 510-742-5887. That's 510-742-5887. Get out of debt now. This is just an advertisement. No attorney-client relationship is created by this ad. The law firm does not guarantee success. He has given you advice on immigration issues on the radio. He has brought you those same issues to the big screen, and now the man who's been looking out for your well-being brings you the story of a man exiled from his home country, only to find out how much worse his life becomes, seeking refuge in his new one. Shah Peerally presents The Immigration Lawyer, Asylum. Learn how one immigrant's trial and tribulations trying to attain political asylum turns out to be a nightmare he never could have imagined. Read about the courageous immigration lawyers and their fight to help others gain their courage to raise their voices against injustice. Shah Peerally's The Immigration Lawyer, Asylum. Get the book available now on paperback at Amazon.com.
The Shah Peerally Law Group is now opening its second office in San Francisco. After years of popular demand, the law group has finally decided to make the big jump and has its presence in San Francisco. For more than 10 years, the law group founded by the prominent attorney Shah Peerally has been dedicated to the immigrant community. The law group's new office is opening on February 20th, 2015, at the corner of 21st and Mission Street in the great city of San Francisco. For more information, call 415-643-4342 or 510-742-5887 or email sf@PeerallyLaw.com. Choose excellence. Choose the Shah Peerally Law Group. No attorney-client relationship is created by this ad.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shah Peerally for the Shah Peerally Law Show, coming at you with over 50,000 watts of power. The Shah Peerally Law Show, where all your views matter.
Hello everybody. Assalamu alaikum, Sastakan, namaskar to all the listeners. This is the Shah Peerally Law Show for a great show on immigration law today, and we're going to talk also a little bit about debt settlement later. But first we're going to start today. I have on the board with me Jermaine, and thank you very much for helping me. And also today we are going to take the calls in few minutes. We have some announcement regarding immigration, but before I start, everything I'm going to tell you today, ladies and gentlemen, is my opinion, and is also is for educational purposes only. You should not act or refrain to act solely on the information provided. If you have any questions on the immigration or debts at the moment or any legal questions, feel free to call our office at 510-742-5887. The website to check is splgpc.com, splgpc.com. I know people are listening to us all over the States and some people abroad too, so I say special hi to all of them, and I wanted to say thank you for continuing support on this show. And of course, as I was mentioning, we're going to talk a little bit about what's happening on the immigration front. For one, on Monday, we talk a little bit about this new, well, it's not new, but this court decision from the Board of Appeals, basically, not Board of Appeals, from the AAO, basically talking about having to do what we call an amendment of petition if you're moving outside the geographical area in an H-1B. Just an LCA will not cut it. We have always said that, but it was not really something that was enforced that strictly, but lately it is enforced strictly. Second thing, we are getting news a lot, few news which are the enforcement side of immigration, especially employment-based immigration, is becoming very strict, so you better make sure that you have your public access files, your letters can be back. For example, a lot of companies are placing their candidates in different areas. Make sure that you have confirmations of those jobs when you are placing them. For example, if you're putting an end client letter, in case they call the end client, you have to, sometimes people don't pick up the phone and things like that, and USCIS, if they call 2-3 times and they don't get anybody, they will make the assumption that there is a chance that this is fraudulent. So make sure you have this cornered. And also now they have a special unit that goes and check on spots. And that's where the amendment of petition is very, very important. Whenever you're moving your candidate outside, changing job, make sure not only you're doing an LCA, but you're doing an amendment. The truth is, this is a very strange rule, but unfortunately, until someone sues and get a good outcome, we will have to do this. Now, if you have any questions, of course, we will be opening the line in 2 minutes, 408-912-5565. Any questions on immigration, H-1B, H-4, L-1, EB-1, EB-2, EB-3, labor certification, adjustment of status, family petitions, marriage, you name it, whatever I can answer, whatever questions I can answer, I will be more than glad to answer for you. And again, this is just educational, so sometimes cases require more assessment. Then you can call us at the office. The number to our office, 510-742-5887. So we will be taking callers soon. So if you call, please, the studio number is 408-912-5565. This is Attorney Shah Peerally live on the show today. So, okay, we have a few callers. Let me take the caller. This is Shah Peerally. You're live on here. Hello?
Hi, Shah. Can you hear me?
Hi. Yes.
Hi.
How are you?
I'm good. How are you?
I'm doing well. What can I do for you, sir?
I have a quick question. So I've heard about this aspect of gap in employment when transferring H1. So my situation is that I have a pending 485. I have an H1 with company A, and I wish to transfer to company B. And it has been more than 180 days since I filed my 485. But I wish to take a 2-week break between the jobs, and I wanted to know if it's okay.
Well, technically, there is 180 days, but the 180 days basically applies for the I-140. A company cannot cancel your I-140 as long as 180 days has passed after the I-45 has been issued. Moving, you can move a little bit later also. That's not a big problem. But the problem is that the company might have a good ground if they want to kind of punish you. They might be able to do what we call, try to withdraw the I-140. You can still fight it, but it can become complications. That's why we tell people to wait the full 180 days, then move. You don't have to really move to a company right away. You can move a little bit later. But until the 180 days has completed, they kind of have a right to revoke it. Also, although we have a chance to fight it, it's not recommended to move before that, because if the company cancels it, then the USCIS might give you a hard time to say you are within the AC-21 period, and then they might just cancel the whole thing. So it is risky, but it is doable. Okay?
Got it. No, but my question was, if I wish to transfer my H1 to company B, and I want to take a 2-week break between the job transfer, is it okay to be without pay, unemployed during the H1 transfer process?
Well, during the H1B transfer, yes, but if you stay too long outside, like 30 days, as long as the transfer is there and the company doesn't revoke your H1B, the new company, you should be okay. You can still take a break under H1B, by the way, because H1B, if you take a break which is a justified break, it is allowed. As long as the company doesn't affirmatively revoke your H1B, you are still okay. But USCIS has taken the position of check stop, but until you transfer, they don't really make a big problem. But if you are during the period, it is kind of okay to transfer. I thought you were talking about adjustment of status. Are you talking about H1B transfer or adjustment of status?
So I have adjustment of status pending, but I also want to continue my H1 application because I don't know when my 485 will get executed.
Okay, then you don't have to a problem, because the adjustment of status covers for you, not in status-wise, but you're in a period to stay authorized by the Attorney General. It's a little bit tricky. It's just a matter of timing. If you want me kind of to analyze the timing for you to make sure you're not making mistakes, give me a call at the office. Otherwise, you should be fine, because the pending adjustment of status protects you, kind of. Okay?
Okay, thank you.
Okay. Good luck to you. So the number to our office, 510-742-5887. We have a few more callers. Let me take another caller. This is Shah. You're live on air.
Hello.
Hello? Yes, sir. I'm listening to you.
Hi,
yes, you're live on air.
Firstly, thank you so much for your show. This is really helpful, and I would like to commend you for the service you're doing for the community. Thank you so much for that.
Oh, thank you so much. Thank you so much for listening. Yes.
I have a quick question about visitor visas. So my parents are here for about 2 months on a visitor visa, and we are planning to visit Canada for 4 days. So would there be an issue at the port of entry when they are trying to re-enter into the U.S.? Because the previous entry was, say, just 1 month before the new entry.
Yeah. Well, yes and no. It depends on the officer at the border. Oftentimes, it's their mood. But the truth is, most of my clients do that. Pretty much everybody is in your situation. They have family in Canada and family in the U.S., and they travel back and forth. For elderly people, I'll say 90% of chances you should not have any problem. But the officer can question you, okay, you just came, now you're going by and you're coming back here. But since they just came, I think 2 months ago, right? So they might be okay with that. They won't give them such a hard time. But there's never a guarantee with them. It all depends on their mood. So just go in a time where they are not too tired or things like that. Then I'm hoping that they should not make any fuss. But I've never seen people getting returned, really. I heard stories, but my clients never been returned while they went to Canada for a couple of days to visit someone and come back here. If they had kind of stayed for like 5 months and then they go to Canada and come back, then they might question it, because they would think that you're trying to reset it to get a lot of additional time. But even that, they still allow it. So I'm pretty...
Actually, it's been only 3 weeks since they have been to the U.S., so by the time they re-enter, it's going to be around 4 weeks.
Yeah, I think they should be fine, because they can always explain that, hey, they just want to visit someone and they're coming back, they want to continue their time here. There's nothing wrong in that. But if they had kind of waited close to the 6 months and then do that again, then it might have been a problem. What they will do, they will just revalidate the I-94 at the airport when they come back, okay? Okay?
So is the concept of automatic revalidation applicable in this scenario?
Yeah, most of the time the visitor visa also, it's the same rule. Yeah, because I had a situation like that where a client of mine, he thought by leaving he will get another 6 months, but they went ahead and just continued the same I-94. Okay? Okay, good luck to you.
Thank you so much.
You're welcome. Let me take another caller. This is Shah. You're live on air.
Yeah, hello, Mr. Peerally. This is Nikhil. Quick question. So, for this H4 EAD, the form acceptance is beginning from May 26th. And
yes.
Is there a cap that it will run out like the way H1 ran out in first couple of days? That we have to do right away to do all that situation?
No, this is a good question you're asking. Actually, if you go on that website I made for H4EAD.com, I wrote about this. As far as I know, I didn't see anything on the law which puts a cap. I think what happened, some people wrote by misinterpreting what was written. They say in that they're expecting 50 to 175,000 people are going to apply. But nothing says in that there will be a cap, because the only condition that they put in there, I-140 has to be approved, or you have to be on the 6-year extension. So no, there's no cap as far as we know at this point. They might put it later, but I didn't see anything that indicates a cap. I think it's just misinterpretation of people reading it, unless I'm totally wrong, but I tried to look for it. But there's no cap. It's not like an H-1B. This is not an H-1B, okay? The cap is set by the H-1B, not by the H-4, okay?
Yeah, thanks, because we were really wondering, because we had to do visas, like we had to take care of certain stuff. So thanks a lot, Mr. Subrali.
Yeah, you're welcome. You're welcome. Let us wait, because also there's a little issue going on in the H4. Someone sued. I don't know if you know about that. Hopefully, that lawsuit will not go through, but they just tried to cut it off. But so far, the law is still standing. So for people who want to apply, they can still call our office too. We can help them, no problem. Okay? 510-742-5887. Thank you so much. Let me take another caller. This is Shah. You are live on air.
Hi, my question. Hi, how are you?
I'm doing well. Go ahead. I'm listening to you.
This is Mrs. Verma, and I had a question about the H4 EAD.
Yes.
My current H4 is expiring on the first week of July 2015. And my husband has I-140, which is under premium processing, but has an RFE on that. And he has an I-140 from his previous employer as well.
Yes.
So can I apply for the H4 EAD rule?
Yes, because the requirement is just an I-140. An I-140. It didn't say which company it has to be from. As long as it's still alive, you can use that. What you should do in your case, and if you need help, we can help you. You should file concurrently the extension and the EAD on May 26th for you.
Okay.
And hopefully, I hope your husband also, because your husband doesn't have to wait for that present I-140 to file for extension on the H1 if he has to. He can still use the old I-140 too. So he can do that, and you can do on your side, do concurrently the EAD and the extension. And if you need help, if there's confusion, give us a call. I'll be glad to handle it for you. Okay?
Okay. And one more question. Is there any minimum validity for the I-94 in this rule, that because my H4 is getting expired, so is there any minimum rule that you should be that much of time before you file for this?
They didn't say any minimum of rule, but then we know for a fact that it will take around 90 days to get that. And if you don't have that, it will be hard. But in your case, what I'm telling you to do is to do an extension of your H4 and the EAD at the same time. So that's not going to have any kind of, that will kind of kill the expiry of your H4. So only thing is that your lawyer has to know the rules so that they know how to do it. This is the biggest problem we are facing. A lot of lawyers are calling me and asking me, how do we do this? How do we do that? Well, I know the H4 because I've been in it for 4 years now, working on it. But even then, even us, until we start filing, we will not see the glitches. So it's like just a software. We have to test it, right? So right now, this is your idea. You have to file it concurrently and your extension. But I will go with the assumption to answer your simple question. At least you have to have 3 months on it. But I will recommend people to file
the previous employer's I-140.
Yes. So he can file his extension of H-1B based on that previous I-140, and you also can file your H4 extension and your H4 EAD concurrently using the same rule, the same I-140. Okay?
Oh, that's great. Thank you for your help.
You're welcome. Let me take another caller. This is Shah. You are live on air.
Hi, how are you?
I'm doing well. What can I do for you?
Okay. So my situation is, I was on company A and I had an approved I-140 in 2013, and last week company B acquired my company. Okay, and they continue in the employment. Everything, all the duties are same. Only difference is that I may have to fly to a different state a few times in a year to, for the business meetings, etc. So they and I have the H1 approved till 2016 August. So they said they don't have to do anything special than just do some amendment or something.
I don't think they have to do any amendment at this point, because if your flying is just regular flying, it's not like they're putting you to travel and stay there for a long period of time. You're still working at the unit where the labor certification was approved, and since your company seems to have acquired the other company, that means if it's a full acquiring of all the assets, and that means there's nothing really to be done. But if in the future they make any changes, then they might have to reconsider either to amend it or to refile a new labor. But we will not know that until there is some material changes in your case. But at this point, from what you're telling me, I don't think they really need to do anything because it's just a full acquisition and merger, so you should be okay.
So what about the green card? Like, I have the I-140 approved with company A, so do company B has to start the process, or?
No, they don't have to if it is a full merger and acquisition. And if it is, there's a term for that, I keep forgetting it, but if they're basically acquiring everything in the company, they're not breaking the company and taking only parts of it, then they're absorbing the company, then nothing has to be done, not even an H-1B amendment, actually, unless there's a change of location, that's different. But the question in your I-140, if they're going to make you, for example, let's say you got your I-140 in Santa Clara, they want you to work in New Jersey for a while, and you have to be working there and continuously, then they have to do a new labor for you. Otherwise, if you're just asking you go to New Jersey in the morning, come back in the afternoon, or go for 1 week for a presentation, this doesn't change where you're really working. You're just going there, and you're not going to pay tax in New Jersey or anything. So this is just an example, but your company lawyer should assess the merger and acquisition. I will not know this until I look at the papers of the merger and acquisition, and since they won't give that to us, only them can really kind of assess it. But as a general rule, in your case, it doesn't seem that you need to do anything. You can still continue at that same green card, okay?
So I got a green card. I just talked to the company lawyer, and he said they will keep the priority date, but they have to restart the labor and I-140 again. So is that correct?
Then they might. Yeah, then they might be right, because I don't know what was in the agreement of the merger. Because if the merger has certain rules that they have to move you from one location to another, and the green card was obtained based on the prevailing wage of a different county, they have to redo it to be on the safe side. But they will keep the priority date. Otherwise, if it is just let's say nothing has moved, they don't really have to do it. But it's very hard to answer this question because I don't know what was the agreement under the merger. So that's the problem, that merger or acquisition, we don't know. But the general rule, you don't have to do anything if everything's staying the same. But if there are changes in location or some material changes, then they have to redo the whole thing, okay?
I can keep the priority date, right?
The priority date, you will keep, no problem, okay?
Okay, thank you.
Okay, you're welcome. Let me take another caller. This is Shah, you're live on air.
Hi, good morning, sir. My name is Sriram, and I have one question related to...
Yes,
I have a question related to H4 EAD.
Yes, sir. I'm listening.
I'm on I-140 and H1. H1 approved. I'm working on H1, but at the same time, I have I-140 approved. And my wife is on H4 right now. And my company attorneys, they are trying to file H4 EAD on 23rd or 26th of this month.
26th,
but
yes.
Yeah, but my wife is traveling in June for 2 months to India. So when she goes out of U.S., is she losing H4 status, and what happens to this EAD application?
Yeah, they should not file if she is going to travel. They should wait for her to come back, because from the meetings and the conference that the USCIS gave on the H4 EAD last time, it seems like there will be a confusion if there's a person leaving during the time on the first EAD when it's being applied. So I don't recommend filing. Even though it's not clear yet, they're just going with the fact that they're not encouraging people to leave during the time they're filing for the EAD. What your wife should do, she just go back, and when she comes back on her H4, then you apply for the EAD. Okay?
Okay. Yeah. Thank you.
Excuse me. Okay. You're welcome. Let me take another caller. This is Shah. You're live on air.
Good morning, Mr. Shah. Thanks for taking my call. I have my parents live in India, and they had multiple visa which is going to expire in 2018, and they're Indian citizens, and their passport got expired, and they got a new passport and added their name into the new passport. If they're trying to travel U.S. next month, is they have to go to visa again or call embassy?
No, they don't have to. They just have to bring both passport together, kind of staple it together, show the visa on one passport and show the new passport. You don't have to go again to the embassy.
But the old passport and the visa name is the same, but the last name was changed. Last name was not on the previous passport. Now new passport, they added the last name. So is there an issue on that part?
I don't know the answer on this one because it all depends how it might create some difficulties when you reach, but usually they go by the passport number. The best is to just make an appointment with the State Department and get a new visa. The problem is that when you go for get a new visa, then they'll reconsider the whole thing, and they might deny the visa. So technically, as long as it is the same person, the fingerprint is the same, the passport number is kind of matching and things like that, you don't have to. You just have to bring documents to show why the name was omitted. But that's a very hard question to answer because I've seen them going both ways on this. I've seen cases where they don't make a big fuss because it was just a mistake, they understand. I've seen them also requesting documents to prove that the same person. So on the safe side, it will be to go to the U.S. consulate and get that corrected. But at the same time, there's a risk. You go there, you ask them they will reconsider the whole application, and there is a risk of denial of the visitor visa. So it's very hard to tell you at this point what is a good answer. Possibly, if I were you, I'll just bring proof that this is the same person, bring some documents attached, and just travel at the airport. And at the airport, hopefully they will not make a big fuss. They will understand this is the same person, same fingerprint, etc. And if they have traveled to the U.S. before, they will be able to match the same person to their fingerprint. So that's very hard to answer, unfortunately, because right now the way things are going with the State Department, everybody who's going there, even to check small things, they're going ahead and reconsidering the whole application, and then they look at all the other factors. And that means like you're applying for a new visa. But unless there was some major problem on the name and you cannot prove that name matches with your parents, then I will not go. I will just bring proof that and birth certificates, other documents together with them when they travel to prove this is the same person. Okay?
Yeah, just the last name was added to the new passport. All information is all as same, there's nothing changed in that part.
Yeah, just bring proof that this is their last name, like birth certificate, ration card, medical records, and things like that with you, okay?
Okay, some more documents to take to travel. Okay.
Yeah,
Thank you very much,
if
sir.
you go to the State Department, again, they will reconsider the application and all the risk of getting denial is there, okay? Good luck to you. Wish you all the best for your parents. Okay. Let me take another caller. This is Shah. You are live in here.
Medical records.
Hello?
Like that with you, okay?
Hello, hi.
Okay. Documents to take to travel.
Hi, can you turn off the radio in the background? Okay. Go ahead. I'm listening to you. This is Shah. You are live in here.
Hi, Mr. Peerally. How are you?
I'm doing well.
Great. I actually have a question in regards to my citizenship. Now, my question is, does a child of a U.S. citizen become a citizen automatically if the child was under 18 at the time when the parent became a citizen of U.S.?
Yes, depending on the time it happened. When did this happen? When did you become a citizen?
My dad became a citizen in 1996, 2 days after I turned 11, but I was in a different country and he was in U.S. So how does that work?
It's not automatic. Did you have a green card at that time?
My dad had a green card, then he became a citizen, and when I entered this country in 2006,
did you have
I have a green card.
No, at that time when your dad became a citizen, did you have a green card? No, you didn't have it, right?
No, I did not. No.
No, then usually they don't give you automatically. You have to go to the citizenship on your own now. Because usually they give that to those people who have already been granted a green card.
Okay, so based on the law that changed in 2001, that any U.S. citizen who became a citizen and they had children who were under 18 becomes a citizen, that does not apply?
It applies for people who have a green card.
Okay. Okay, so
and then the law of citizenship has been changed. The law of citizenship changes over time, so it's that's why I was asking you the date, and I don't have the chart in front of me. But technically, I don't think you're a citizen yet. You have to apply your own citizenship. If you have a green card, you need to apply in your own. They will tell you right there if you're a citizen, because sometimes it's very tricky, this stuff. It's very hard for me to answer on the radio because I myself get confused on the dates when I match it. But technically, it works this way. If you had a green card at the time when your father became a citizen, yes, they will grant you your citizenship automatically. Otherwise, you have to go to the green card process, then move to citizenship. Okay.
Oh, okay. So in that case, so I need to do N400 instead of N600?
Yes. I think you should do the N400 in your case. And if you're already a citizen, then at the interview they will just tell you, oh, you're already a citizen. From our record, we'll just give you your certificate. So if I were you, I'll file for the N400 at this point. Okay?
Okay. Thank you so much, Mr. Peerally. You have a great day. Thank you.
You too. Good luck. Let me take another caller. This is Shah. You're live in here.
Yeah, hey, good morning. My name is Karthik, and I had a question.
Mm-hmm.
Yeah.
Yes, I'm listening to you, Karthik.
Yeah, sorry. So, I got my green card through employment 3 years back, and 4 years back, actually, 2011.
Mm-hmm.
I want to know, when can I apply for my citizenship? When can I start the process to apply for my citizenship?
Okay. You got it to employment-based, right?
Employment-based in June 2011.
Okay, so your green card, you count the anniversary 4 years and 9 months of the green card. No application or anything, but the green card date, you count 4 years and 9 months.
Okay.
So it's probably going to be beginning of 2016 then, if my math is good. It should be beginning of 2016. 4 years and 9 months you can apply.
Okay, so that's when I can start So what happens if it goes fast, or before, or what happens generally?
Before, it will get rejected. After, it's fine.
Okay.
Before, it will get rejected. Okay?
Okay, so before 4 years and 9 months, it's okay. So you can't apply before 4 years and 9 months.
You can't apply. Yeah, they will take your money, enjoy it, and they will just reject you. That's the way they do it. So you just have to just file it after that, okay?
Okay, but anytime after that is fine.
Yeah, that's fine. Just make sure you file it as soon as possible because you don't want any kind of problems coming. People sometimes delay and they find themselves into missing dates, missing time, or have some kind of criminal thing coming without even knowing. So you as soon as you get a chance to file citizenship, and if you need citizenship, you should file it. Okay?
Okay. Perfect. Thank you.
Okay. Good luck to you. Let me take another caller. This is Shah. You're live in here.
Hello. Dr. Peerally. So I have a question. I have a I-140 from a previous employer, employer A, and then I am in company B now, and I will my I-140, my H1 will expire next year, August of 2016. 6 years will get completed. So I'm wondering if I move to a different company now, will I get a 3-year extension?
If the I-140 is still alive, has not been revoked, technically you are eligible for 3 years. That's one thing. Eligibility doesn't mean they will give you 3 years, because oftentimes people call me, they say, hey, on the radio you say once you have an I-140, even from a different company, you get 3 years. Also, you have to take the factor in. Oftentimes now, if they will look at if you're working especially for a placement company like a consulting firm, depending on the end client contract, if it is less than 6 months, they usually will give you only 1 year extension. But be careful if you're using an I-140 from a company and when you leave they're going to cancel it. Make sure as soon as you wait for an approval before you move, because without that I-140 you won't be able to even move after 6 years. So, technically to answer your question, yes, you get 3 years, but the 3 years is subject to depending your situation of employment. If your contract is less than 6 months, they will not give you 3 years, okay?
Okay, and one follow-up question for this. Suppose I don't, suppose they would give only till September next year, 2016, the extension, which is when my 6 years ends. Can I, so if I start my processing of a green card in, let's say, August of this year, I mean, the firm and labor, depending on the current timelines, do you think it is still risky for me to do such things?
Yes and no. The only problem is that it's very hard to tell because I have to kind of calculate the time. Usually I tell people move, if they have to be doing a new I-140 or labor, have at least 1.5 years in your hand to be able to be on the safe side. Because the time it gets ready, it gets filed, etc., etc. But I've done cases where people had only 6 months in their hand. It's just a matter of being tactical and the lawyer moving fast. So it is okay since you have till September. Right now we are in May. You should be okay, but you need to move as soon as possible and make sure you have a good I-140. And the dates has to be calculated. If you want me kind of to calculate the dates, you can just give me a call at the office and I'll sit down with you and calculate the good timing. But right now, from what you're telling me, you should be okay, but make sure it's good to have this I-140 alive for you, okay?
Okay. And also, one last question. So, I can also add the amount of time I spent outside in India, right, during H1?
Yes.
So that should be a
capture of time. Yeah, that will add time for you too. I forgot to mention that. That's good. Yeah, you can do that, okay?
Okay, thank you very much, sir.
Good luck to you. Let me take another caller. This is Shah. Are you alive in here?
Hi, good morning. My name is Sarah, and I'm a citizen, and I have green card for my parents. My dad is like 80 plus, and they had gone to India 2 years ago, and there he had some medical issues, and so he had a surgery and stuff. So it's been 2 years now. They are in India. So I'm wondering what happens to their green card. If I bring them back, will they be able to enter the country, or do we have to do some other procedure, or how does it go now? I'm not sure.
Okay, if your dad had surgery, it's considered kind of extraordinary circumstances. What you should do, you ask them to go to the U.S. Embassy and ask them to, I forget the form number. There's a form and you pay a fee for that. They will revalidate the green card. Yes, can you hear me?
Yes, I can hear you.
Yeah. So you go to the U.S. Embassy, take that green card, and bring the doctor's paperwork that he had surgery, and then ask them to revalidate the same green card. If they don't revalidate it, then you'll have to start the process again, or ask them if they want to give them a visitor visa and give up on their green card. And then when they come here, then you can decide what to do, okay?
So what should we do? We should take an appointment in India, U.S. Embassy, and then go there with all the paperwork?
Yes. Yes. They have a special form for that, okay?
Okay, thank you.
Okay. You're welcome. So, ladies and gentlemen, we're going to have a quick break. I know there are a lot of callers waiting. We're going to have a quick break and have some messages, and then we will be back after those messages. And this is Attorney Shah talking live from KLOK 1170 AM. And anything I told you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. So feel free to call us. The studio number is 408-912-5565. We're going to take a quick break, German, and then we will be back after those messages.
Is your credit card debt driving you insane? Don't panic and claim bankruptcy. Don't consolidate and end up worse off than before. What you need to do is call the debt settlement team at the Shah Peerally Law Group PC. They have an excellent record of getting your debt reduced at a fraction of what you owe. The best part is you don't pay a penny until a settlement is reached. Stop wasting time and money and call the Shah Peerally Law Group PC at 510-742-5655. 5887. That's 510-742-5887. Get out of debt now. This is just an advertisement. No attorney-client relationship is created by this ad. The law firm does not guarantee success. The new Attorney On Air app is now available to download on your iPhone or Android. Get access to the latest information and interact on the immigration and debt settlement blogs. That's not all. The app has plenty of entertainment as well. Listen live to the Shah Peerally Law radio shows. Go to www.attorneyonair.com to download it for free. Yes, that's right, for free at www.attorneyonair.com.
The Shah Peerally Law Group is now opening its second office in San Francisco. After years of popular demand, the law group has finally decided to make the big jump and has its presence in San Francisco. For more than 10 years, the law group founded by the prominent attorney Shah Peerally has been dedicated to the immigrant community. The law group's new office is opening on February 20th, 2015, at the corner of 21st and Mission Street in the great city of San Francisco. For more information, call 415-643-4342 or 510-742-5887 or email sf@PeerallyLaw.com. Choose excellence. Choose the Shah Peerally Law Group. No attorney-client relationship is created by this ad.
And we are back, ladies and gentlemen. This is Shah Peerally for the Shah Peerally Law Show, and today I have on the board with me German. We have a few more minutes to go for the show, and I know there are a lot of callers, but before I take the callers, I wanted to let you know also our law firm handles debt settlement. This is where you have credit card debt, student loans, etc. Student loans is not that easy, but still some people can be helped. We can get rid of those debts for you. If you have judgment against you, instead of going to a bankruptcy, give us a call, 510-742-5887. We have a special website for it. It's called yourdebtsettlementattorney.com, yourdebtsettlementattorney.com. Give us a call. We'll be glad to help you. Let me take another caller, German. This is Shah Peerally. You're live on air.
Hi, Shah. Good morning. This is Jagdish. I have a question regarding change of status from H1 to H4.
Yes.
My wife came on H4, got stamped in India, and came to US in 2013. And later, 2014, she got a job with her employer and they sponsored the H1B. And now, actually, she's planning to quit her job and move to H4. And so we are planning to go to Mexico, US-Mexico border to do the change of status. So I just need a suggestion on that, like when we go and then cross the border of US and then while coming back in, so to do the change of status, so what are the documents we require and will there be any questions asked by the border security people and how to face those?
Well, that's a very broad question, but you have a stamp of H4 on the passport, right?
Yes, that is valid until 2016.
Yeah. Well, technically, no. People go to vacation to Mexico all the time unless they know there's some kind of fraud or something wrong was going on. But there's no special question. Having said that, lately we have been seeing a lot of enforcement at the airport. We had a situation where basically they went into the full H1B of the person and check that she made a mistake on her resume and things like that, and they say she lied and they gave her a hard time. But the truth is, for H4, most of the time, the only thing you have to bring is proof of your relationship marriage certificate and your approval notice on H1. She should be able to come back. Okay?
Okay.
Hello? Okay, let me take another caller. I think I lost this one. This is Shah Peerally. You're live in here.
Hi, good morning, Mr. Shah. I had a question. Me and my wife, we acquired U.S. citizenship in the year 2013. And during that time, our son was 17 years old, so he automatically became a citizen. And we applied for his U.S. passport. Is it necessary that we apply for his certificate too, or is it important? How does that work?
For immigration purposes, no, your passport is good. But I've heard from some of my clients, they say when the kids reaches a certain age to go to university, they are asking for that certificate. So just to be on the safe side, it's good to apply for this certificate and keep it, because you never know, they might lose their passport and things like that. If I were you, I'll go and apply, do the form N600, apply for it, and keep it. Even you have to pay a fee. It's recommended, but it's not something necessary. Okay.
Okay. And also his green card, do we have to, when we apply for a certificate, that time we can turn in his green card, right? Or
you should have turned the green card. You should have turned the green card a long time ago. That green card, you cannot keep it. Yeah, you should. If they ask for it, you return it. Or
no, because he automatically became the citizen because he was a minor during that time. He did not go to any interview. So the green card is still with us. So
yeah, but you don't going to say that, because technically the problem that you're facing is when you went to the citizenship oath ceremony, they take that green card. You were supposed to surrender your kid's green card too. But that's okay. You can just send it in the package. Don't send it and just ask them if they want it, because I don't know the answer really, because this should have been taken a long time. It's probably a mistake. So you can always do an InfoPass appointment and go and surrender it there. Be careful you don't lose it and then you bring it there. But technically that green card has no validity, but it should have been surrendered at the time when you became a citizen. But it was just a minor mistake. You can just go there and give it. But don't mail it in the package unless they ask it. Right now, just apply for your N600, okay?
Okay. All right. Thank you very much.
Okay. Good luck to you. Let me take another caller. This is Shah. You're live on air.
Hi, Shah. This is Vikram here. I had a question on H4 EAD.
Yes, sir.
My I-140 is approved, and I can apply for H4 EAD for my wife, but the glitch is that my H1B is expiring in December 2015, and my company is going to apply for an extension for 3 years in June 2015. So along with that, my wife's H4 also will expire, so I need to apply for extension for H4 as well. So I wanted to know how to time it. 26th May is the H4 EAD date, and I can of course apply after that also.
There's nothing really to time in your case. You just go ahead, file for your EAD, because they never said that extension will kill the EAD. But the problem is only, unfortunately, if you apply, by the time they give it to you, your H4 is not long term. They might stop the EAD at the time of the H4. That's the only issue. But you can always reapply when you apply for the extension.
Should I apply for extension
ask your company if they can do your H1 earlier. You have 6 months. You can apply for the H1 6 months before.
Yeah. So should I apply for H4 extension as well at the same time as H1 extension?
Yes. You have to apply the H1, H4, and the EAD at the same time. Because by that time it will be around July or June. Then you don't have to apply on May 26th. You can apply later. Apply everything together. That will be on the safer side for you. Okay?
Apply H4 EAD, and H1 extension, everything at the same time.
Exactly.
Okay, and do you think it will take longer to get the EAD then?
I'm sorry?
Do you think it will take longer to get the EAD then, if I were to tag it with the H1 extension?
I don't know, but I don't think so, because it's going to be kind of the same processing time. It might delay maybe 10 days, 12 days, but at least you're better off than having an EAD that expires in December, then you have to refile again.
Right.
Okay? Okay?
Okay.
And if you need help, give me a call. A lot of people are hiring us to do the EAD because they're worried that most of their company lawyers don't know how it works.
Call your office.
My
company is not giving me the I-140 copy. Is that okay? Or
I know. This is the biggest problem they're all facing. But yeah, the receipt number is good enough. But it's good to have the company lawyer apply for you because they have all the documents. But if you need help, just give us a call. We'll be glad to help you. Okay?
Okay, thank you.
And the number 510-742-5887. And for those who want consultation, we have one more caller, and I think it's going to be the last caller. This is Shah. You're live on air.
Hi, Mr. Ali. I have a question about applying for a visitor B2 visa for my mother-in-law.
Yes. Mm-hmm.
So we live here, and both me and my wife has a green card, and we needed to apply for a visitor visa for my mother-in-law. I was wondering, should I be sending the sponsoring document or maybe my wife? Which one would you recommend?
There's no real good answer on this. Unfortunately, the visitor visa doesn't really go by the same rule as other visas. It's very discretionary. It will be because you have to mention that their daughter is here anyway, so they will ask the question, how come your daughter is there and she's not giving the I-134? But since you're married, it doesn't really matter because unless your wife is not working, then you put your name. Otherwise, you can put both names on that because the support document, the I-134 that you send, is just to prove that they will be here and not be public charge. They will have their own money to spend here. But there's no real difference because at the end of the day, you're married and you'll have to disclose that they have children in the U.S. So either you or her, whoever is making the money, or both of you can put your name on it. I'm pretty sure you will have to put both because it's probably joint income. You live in California, right?
Correct. We live in Bay Area.
Then you might have to put both anyway, so it should not even be an issue, okay?
Yeah, sorry, one related question I wanted to ask. Can I ask?
Go ahead. We have 1 more minute to go. Go ahead.
So she's right now widow. So is that okay? She apply alone, or maybe it might make sense like she goes to apply with like my brother-in-law? Is there any suggestion you want to recommend?
No, there's no. Like I said, there's no hard and fast rule on that. It's all how they look at the way the visa is progressed is operated. It goes with the totality of circumstances. What they are looking for is ties to India or whichever country she is from. You need to show that she is going to go back. So if she has some medical paper or medical reason she has to go back for her doctor, you show that. If she has businesses there, you show that. If she has property, you show that. It won't make any difference she's traveling alone or not. But if she's sick, then of course they might ask her why you're traveling alone. It's very much, unfortunately, it's not. It's logical. It's pure logic, pure common sense, but at the same time, it's counterintuitive. When you reach the counter, I've seen cases where people don't give anything; they still get an approval. I've seen people who give a big stack of good reasons, and they get denied. So you go there, you just stay natural, just be normal, file it, and then hope for the best. Because there's nobody really who can really kind of predetermine that you will get that visa. It's all a whole situation. And since you guys are not citizens, I am pretty sure that she will get it. Okay?
Okay.
Okay, good luck to you. Wish you all the best. Okay, ladies and gentlemen, we have 2 more minutes to go, so we won't be able to take any more callers. And I thank you all for calling. We had a lot of flood of callers. I want to thank you all. We had people calling all over the states. And you can call our office if you want a consultation, 510-742-5887. And before I go, I wanted to talk a little bit about debt settlement. This is another area of law we practice in. We help people to get out of debts. If you have debts on credit cards, second mortgages in some situations, not everything, because the house market booming now. They have equity. If you don't have equity on the house and you have a second mortgage, call us. And if you have a judgment, people sued you and they got money against you, but you're worried they're starting to put attachment on your properties, lien, etc., give us a call. We'll help you. 510-742-5887. And, of course, if you have any immigration questions, call us at the office. And just to let people know, for immigration, we have a consultation fee. The only free I do is usually on the radio because that's where I give my social work. But I wanted to let you know. But for debt settlement, we will assess it without any fee. But when we get a deal, then we charge the fees, charged usually on a contingency. So I wanted to thank you all for listening today and German to be on the board. And anything I told you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And check our websites. For H4 is H4 EAD, H4TOEAD.com. Our main website, SPLGPC.com. And for debt settlement is yourdebtsettlement.com. settlementattorney.com, one word. Thank you very much, ladies and gentlemen. I'll be back on Monday from noon to 1 for another Shah Peerally Law Show. Thank you for listening, and keep listening to KLOK. Bye-bye.
Visit desi1170am.com and stay connected to your